So we have some 15 minutes, and we have discussed, just to recap, the ability or the power of design to regulate whatever privacy challenges we have. We have seen a specific privacy case which both the problem and the solutions may come from technology, and that was the case of anonymity. We have seen the regulator as a potential solution or source of solution for privacy and some other technological challenge, the FTC. And finally, we have seen some newer challenges of AI that challenges to the law and challenges to all of us. So, ladies and gentlemen, questions, thoughts, ideas, comments, other challenges? Yeah, please. Speak up. Yeah, please do.
Now, yeah, this idea of a human-centric artificial intelligence means that the individual should, in all cases, have the possibility to, let's say, to sue someone to get reimbursement. Yeah? So the individual should not be forgotten. That's the idea behind this European regulation. And at the moment, it could be the case that there are some problems that cannot be solved with European or German law. That's a general answer to your question. And more specific, if something like that would happen today, to my mind, it would be very clear that the producer could be held liable, because now he knows what can happen, and now he must introduce some additional systems, for example, systems that somehow detect when a driver has lost consciousness and is still holding the wheel. And as far as I know, they've done that. They came with a lot of people, technology people, analyzed the case, and they are constantly improving their cars. And so from the technological side, I think things are more or less clear. The problem is the legal side has not yet been able to find a fitting framework to give a motive to the producer to constantly improve the cars. The legal system somehow is lagging behind.
Please, Yuval. Yeah, please do.
A very short answer. I think this is exactly the relevant point. Yeah, and you can compare this lane keeping assistance systems, let's say, with airbags. Airbags will save 1 million lives, but then in some very rare cases they explode because there's a hole in the ground. Nevertheless, we want these airbags to be built in the cars, and we will refrain from holding liable a company that builds in airbags. On the other hand, we want the company to make the airbags as safe as possible. We would not accept one of 10 airbags exploding when the company has a technical possibility to make them safer. So we see a moral duty for the company to make the airbags as safe as possible, and the task now for the lawyers is also to develop a legal framework that gives a duty to the producers to make these airbags as safe as possible. And my solution, the solution I suggested, was to use the concept called accepted or acceptable risk, which means we accept only those risks that are inevitable. The company has to do everything it can to make the system as safe as possible, and only when it's no longer possible to make the system any more safer, we would refrain from holding the company liable. But this is still quite in discussion, this problem.
This raises the question of which criteria do we want to use, and what you've suggested and came up in the discussion is a utilitarian analysis, whereas the AI brings up issues that philosophers have been discussing for many, many years before AI, the trolley cases. What happens if a trolley comes in and if it goes here, if it goes there, should we intervene to save lives or more lives, or there are lots of variations there. Some philosophers would say we should not interfere, okay, and others say let's have a calculus, but then, it sounds okay until it's us. The person hit by the car, etc. So that becomes more difficult over there. Privacy issues. Yes, privacy? Yeah, please go on.
Is it on now? Yeah. So I think it's a different problem, and I think that's not, I wouldn't call that an anonymization problem. To me, anonymity is about putting a name to a piece of data or to an action. In this case, you're talking more about the intermediaries not taking care of that information properly and being able to have I would call that accountability, in the sense that they are holders of private data and you want to know who failed in their duty of care. And for that, you might put some special features on the data sets and be able to kind of do taint analysis to trace who might have leaked information. But I think that's a different problem from anonymity. You don't have a data set of intermediaries and then you want to identify the same set of users. Yeah? Yes. Yeah, sure. Yeah, I mean, as I say, I think that's definitely a very interesting approach to take in order to hold accountable those who have failed in taking care of the data. But I think it's a related problem, but I think it's a slightly different problem from having strong systems that are able to anonymize data.
Thank you. Yes, please. Yeah, Berkeley. Woody, Chris?
That's a great question. It is often said that the GDPR it favors the kind of dominant players. On the other hand, there is a substantial growth in privacy service providers that are at all levels. So, the big companies have spent a huge amount of money on compliance. It's rumored that one company spent $100 million on GDPR compliance, a single company. But getting out of that tier into the SMB tier, there are a number of service providers that help with compliance. And so I think it's going to be like a lot of other product safety and quality issues out there. There will be experts who reduce the compliance cost. But I think the other issue there is both in the U.S. and with the GDPR. It tends to be the larger companies that are going to have the regulatory target on their back. So the class action attorneys don't go after small companies because there's no money to collect. And interestingly, the Federal Trade Commission doesn't either. The Federal Trade Commission tends to focus on large companies. It's not what you'd predict from like public choice theory. There's a focus on the dominant providers. And I think here in Europe too, there's going to be a lot of focus on the big companies rather than SMBs. It's a great question.
So I do share a lot of these concerns. And I think that one of the solutions that's been proposed, at least in conversation, that I think is really interesting, is the idea of separating out data protection regimes into tiers. So perhaps there are data players and there are data non-players. So the idea being that the GDPR and a lot of other companies tend to be agnostic as to business models, right, or the size of the business or the things like that. It's like if you're collecting personal data, then you're in. But you could imagine a series of regulatory frameworks, one that applies like GDPR style to major companies that want to do data analytics, Google, platforms, anyone that wants to actually use data. And then there are a lot of businesses that want to use data, but really only to deliver a pizza, right, or other small, sort of what we might consider to be inconsequential or at least very small and not very concerning uses of data. And you could imagine a second regulatory regime applying to them that had much clearer rules, easier to follow, but also had a lot more constraints. But that would be fine, presumably, with those businesses because they weren't going to be data traders. And so I guess all of this just sort of... what I'm throwing out there is that maybe we should have a little more regulatory imagination rather than treating all businesses the same.
Right. The gentleman over there. Yeah, you. Yeah, please.
Going back to GDPR, an interesting wording which is informed consent. The question is to very where informed consent and they demonstrate.
So that's a really great question, and for those that didn't hear the question was about GDPR. No, so, and generally speaking, I'm just repeating it. The idea is, is informed consent possible, right? Is there a demonstration of informed consent? As I read informed consent, I suppose it's theoretically possible, but it's basically almost impossible. And here's why I say that. So consent is only valid when there are a set of preconditions that are met in order for it to be knowledgeable and voluntary and all of this sort of long list of things that it requires to be. And that's that the decisions that, and the reason that we decided to pull from consent in the first place is because it worked in other areas, right? So we use informed consent before you have surgery, for example. But when you're having surgery and someone says these are all the risks, that's a decision that's infrequent. First of all, you don't make it all the time, which is the exact opposite of data, where you're making that decision all the time. The risks are visceral. I can imagine someone leaving a scissors inside my body, right? But I can't imagine the harms that come from data. And then finally, the harms that come, I have incentive to take that consideration seriously because one mess up could be really damaging to me, right? So if I make the wrong call, then one bad thing will happen. But that's not the way data works at all. I could make the wrong call 100 times, and it still doesn't actually hurt me. It's the cumulative effect of decisions that matters. And so I think that informed consent, by its own stated goals, is more or less impossible.
Yeah, there's some debates here about right, the European versus American approach. Kind of obviously, I think everybody agrees that consent fails, right? Because nobody reads, it's long, it's cumbersome, it's legalese, etc., etc. But then it still captures the idea of autonomy and our dignity. I will decide whether I'm willing to give the data and to whom under which conditions. And there are lots of situations where it can still work, kind of the small, medium, large data situations in the workplace, in the university context, in research context, in, small business, the pizza, not the Google pizza delivery system, but etc. But Claudia, you wanted to
just
in on that?
To add to that, I fully agree that consent is extremely hard, and I would say that it's also. Did I lose my train of thought? Oh my God! Let me give a second.
We can come back.
Yeah, we can come back to it. You don't know the consequences that will. Yeah, I got my thought again. So the problem with consent is also that we're putting the responsibility on people. It's about you're giving the impression that you're empowering people, but you're actually shifting responsibility to them. So then when things go wrong, you can say, "But you consented to this, so now it's your fault." So that's also my concern. My concern with consent. That it's a double-edged sword in a way.
Sure. More questions? Yes, the gentleman over there. Yeah. Yeah.
Okay, I think the colleagues put the burden of, or the honor of answering you on me, and my English isn't perfect. I'm not quite sure whether I got all the details of your question, but the basic things seem to be that there's a driver who does not want to use the possibilities of modern technology, and he will not give away all this information and will not use the possibilities of these connected cars, and then something happens, a harm is created, and can this driver be held liable? And my answer would be yes. My answer would be yes. If a certain technology is available and you willingly refrain from using it, then you could be held liable. Just imagine someone who wants to have a wonderful adventure experience by using Porsche cars without brakes. Yeah, or brakes from the last century. And he will say, I will have a very fast car, but I will have brakes that are 50 years old. I will not use this modern technology. And then something happens. Well, of course, this driver would be held liable because he did not use up-to-date technology. And the same would be true for the use of data connections and everything else. So in a certain way, I think there is a legal duty to conform to technological progress as soon as you interact with other people on the street or in the streets.
And more broadly, if I may add, is that we have a social task, and that is to enable people alternatives So if I'm unwilling to use a specific technology, or I want to use it on my terms, but then I will be liable, I should have alternatives such as public transportation, or that sort of alternative.
And I'll just add briefly that there are also elements of anonymization that matters here, where it might, maybe we don't want to give it as a consent regime, but just anonymize data. And then also, it brings up the importance of trade secrecy, whereas companies might have obligations to disclose certain kinds of information as we get into collaborative systems.
Mm-hmm. Thank you. The gentleman over there, yeah, please.
I'd like to turn to very transparency about the algorithm.
Yes, I think that's a very important and also complicated point. The philosophers and also part of the lawyers wanted this transparency. But on the other hand, the people from the company argued, if we make our algorithms totally transparent, we will lose a lot of money because these algorithms can be copied by everyone. And another point is certain types of machine learning, for example, do not seem to be transparent at all. You cannot analyze from the outside what these things, what these machines are doing, and therefore this whole idea of total transparency is points to a wrong direction. And I think it will be the task of the lawyers in the future to bring it down to a reasonable standard. Yeah? Perhaps arguing transparency as far as possible, technically possible, and legally acceptable. Yeah? We don't want to block innovation by forcing companies to open up their secrets, their trade secrets, and algorithms can be trade secrets. So this point must be considered. And then, of course, a law should not impose a duty that you simply cannot fulfill if these algorithms are self-learning and nobody is able to analyze this process in detail and predict what the machine will do after the learning process, then it's unreasonable, nonsensical, yeah? Absurd to say the process must be transparent all the time. It's simply not possible. So I think this is an important point, but there are possible answers to that.
Indeed, and we have seen some solutions to that issue in pre-AI cases. When a company develops a new kind of food or medicine, it has to undergo certain authorization and by the FDA or ministries of health or those kinds of agencies to make sure that it's okay, and they reveal only to the agency, right, the trade secret, and so it remains a secret for competitors, but not for some authority. And if they are sued and they want to defend themselves and explain why their product was okay, they will have to reveal or pay whatever they're sued for. Ilana, we are done. Okay. So lots of food for thought, and please join me in thanking our colleagues on the panel. Thank you.